Welcome to Issues and Answers. I'm Ian Boyne. Our focus today is on justice. We have with us the Minister of Justice, the Honourable Delroy Chuck. We'll be putting to him some of the issues we are sure you want to have clarified. We thank you for your company. Minister, good to have you.
Very happy to be with you again.
On the show. I know this issue of the backlog in the court system is one which has occupied your mind and is a major focus of your ministry. What are the major initiatives to deal with the backlog of cases in our system?
Well, let me say this is my major focus, certainly over this year, and as long as I'm there at the ministry, will be my focus until we can get cases and justice delivered in a timely manner. The situation now where cases are lagging for years, sometimes over 5 years, we must deal with. My hope is that by sometime in 2017, no case should be in the court over 5 years. And certainly my hope is that by 2017, perhaps into 2018, that no case should be in the courts over 4 years. And by 2020, my hope is that no case should be over 3 years. Now, I am not going to blame any of the stakeholders in the system. There's enough blame to go around. And certainly in the Ministry of Justice, we have a duty to provide the necessary resources to make sure that the stakeholders, such as the judges and the prosecutors, that there are enough to try cases. At the same time, we need to put in place more courts. So at the moment in the Supreme Court, we only have 4 courts for criminal matters. We have more for civil matters, but let's deal with the criminal matters. 4 courts, not enough. My hope is that by next year, we should have at least 8 courts, preferably 10 courts in the Supreme Court downtown, trying cases. Having said that, you may have 8 or 10 courts, then we need more judges, because you need more judges to try the cases, and we need more prosecutors, which mean more support staff in terms of secretaries, in terms of persons assisting in the prosecutor's office, also in the judges' chambers and assisting the judges. So resources will have to be pooled to ensure that if we have 8 or 10 cases, courts trying criminal cases, that they can actually come about with more cases being tried. We're working on that. But with all the resources in the world, the number of cases in the Supreme Court and in the parish courts across the island, we will never be able to do all of them.
What's the numbers we're talking about now, Minister?
Well, you take in the Supreme Court, each term, they carry over about 500 cases. Now, bear in mind, with 4 courts, you can't try more than about 4 cases, average of maybe 10 cases per month or per week, because one
they carry
case,
over 500 cases.
That's right. One case could last 3 weeks. Some cases last months. But once a case is started, it usually lasts 3-4 days. So you're talking about less than 10, or an average of about 10 cases per 2 weeks or per month sometimes. I have no doubt that we have to develop a system where many of the persons who are charged and the cases, the files have been completed, even when the files have not been completed, that we have a process whereby plea bargaining, where the defense counsel and the prosecutor can look at the case and develop some understanding what would be an appropriate sentence and take it to a judge. We have in mind to put in place a plea bargaining judge. So let us say in the Supreme Court, you could have a plea bargaining judge who would listen to the prosecutor and the defense counsel and come to some decision what would be an appropriate sentence if a guilty plea was entered. Now, that plea bargaining judge must never or will not be the judge to try the case if in fact there is no agreement. But if there's an agreement, then
matter can be dealt with
right away. And I say without fear of contradiction,
makes sense,
that if the accused participated via his attorney, his defense counsel, And he knows that if he's convicted, a sentence is in excess of 10 or 15 years. And he knows that his defense counsel could bargain with the prosecutor before the judge and get 5 years instead of 10 years. There's a real likelihood that he may accept,
Because
enter a
right
guilty
now
plea.
in our plea bargaining system, the defense counsel is not
The
represented.
defense counsel is not represented at all.
And you are proposing.
I'm
that that be
proposing
changed.
that he engages with the prosecutor,
Okay.
with the judge, in a sentence to be imposed. The legislation needs to be changed. At the moment, there is on the book what is known as plea bargain legislation, but it only allows where the accused gives information to the prosecutor
Yes.
to be able to convict other persons or in some other way. That's too restrictive. I would like to
You
see
want a broader
a
plea
broader
bargaining
situation
legislation.
where in any case, in the parish courts, in the Supreme Court, a case is there, you know that there's going to be a period of a plea bargain judge to listen to the case if the party is willing to plead guilty, with the understanding that his defense counsel can say, I get less than 5 years, I'm willing to plead guilty. If I get a non-custodial sentence for minor offenses, I'm willing to plead guilty. Even for minor offenses, just like in the ganja convictions now,
Yes.
we may even offer the carrot that the conviction will not be recorded if it is a minor offense. But always in this plea bargaining process, it will be under jurisdiction of the judge, and the judge must have the final say.
That seems an excellent way to cut down on the number of cases. But doesn't it represent a kind of softening? Would this be an incentive to people to just do wrong, thinking that they can get off easily? When we come back, we put that question to the minister. We take a break on Issues and Answers.
Motorists, know your rights as road users. If you're stopped by the police in a road check, the police have the right to ask for your driver's license and vehicle documents. If you don't have the documents on you, you can ask for 5 days to provide them at a convenient police station. If you don't have vehicle insurance, you can be prosecuted and face the court. If you fail to renew the registration license, the police are entitled to seize your vehicle. If the police wish to search your vehicle, they should tell you the reasonable grounds for wanting the search. If you are given a ticket, sign it only if you plan to pay the fine and not contest the charge in court. And please be reminded, children under 18 years must wear a seatbelt, even if they are seated in the back. Know your rights. Knowledge of the traffic road code makes it easier to work with the police as they do their job to make the road safer for you and everyone else.
Welcome back to Issues and Answers. Minister of Justice, the Honorable Delroy Chuck, is speaking to us about initiatives to cut down on the backlog of cases in the courts. This is one of the things which are making our justice system not deliver the kinds of outcomes that we want. And the minister has some ideas as to how to improve the justice system. And I'd raise, Minister, at the break, the possible objection of some that, well, this is kind of a softening things, or we need to toughen things.
Not at all.
Yeah.
First of all, we will put in place very short, in fact it's already there, but it's to be publicly acknowledged, sentencing guidelines. So you will have sentencing guidelines, and certainly a guilty plea may well be at the lower end of a sentence. What is more, I would also propose that victims or the families of victims should have a say, so that the prosecutor should really consult with the investigating officer and maybe with the victims to say the accused would like to plead guilty. What would be your position on this? And get some understanding, the sentiment. Indeed, we have just presented, and it was just passed in Parliament, restorative justice bill. Now, with restorative justice, it's a situation in which the offender is willing to say, yes, I'm guilty. The victim will say, I'm willing to forgive the offender. And based on that, some understanding can be reached between the victim and the offender at pre-trial case, at trial stage, so that even at trial stage, if the victim is willing to forgive and really say, I understand and I'm willing to make up with the offender, because most crimes, are domestic.
Yes.
The offender is known to the victim and vice versa. So to the extent that one is willing to admit his guilt and wrong in the engagement, and the victim is willing to forgive, then you can see immediately that the judge is put in a position to impose a sentence which will not only extend mercy, but will in fact be the due justice in the case, especially if the victim is taken into consideration. So I'm not putting this plea bargaining and this restorative justice as something that will be soft or will not send the right signal. In all of these situations, it's a case where you will consider the feelings of the victims and the public interest, because the public interest will always have to be taken into consideration. What is more, if it is a murder case, let us say it's a murder case or a manslaughter case, depending on the nature and gravity of the circumstances, there's no doubt that in many of these cases, 15 years, 20 years would be the norm. So that it would be unlikely that you plead guilty and get a suspended sentence or a non-custodial. I mean, then the plea bargaining would fall into disrepute. So defense counsel will have to understand and say to the accused, you have been charged with murder. If you plead guilty, the normal sentence is going to be 20 or 30 years, and you have to serve for 15 years.
So for the most serious crimes,
there's no doubt it's going to be a
strong
prison sentence.
punishment would remain.
The question is the length of the sentence.
That's right.
Would 8 years be acceptable to the accused? Instead of you going to trial and you're there for weeks, you're hold up the court for many years because it's on the list. Yes. So to the extent you say to all defense counsel, here's a plea bargaining situation, here's the sentencing guidelines that the judges would have put down. Are you willing, you urge defense counsel to encourage their clients to go before a plea judge with a view to pleading guilty, and hopefully, I have no doubt, more than half the cases could be resolved. Yes. And then you have those really serious cases of contention where a judge might say, this case is so grave that if you plead guilty, you get in the maximum. And the accused might say, well, I'm willing to stand my chance.
But the fact is that the vast majority of cases which clog up the courts are not those most serious cases, are some things which could easily be dispensed with.
When you go into the parish courts, they're clogged up with stealing, shoplifting, I mean, all sorts of minor matters. Where, to be frank with you, a guilty plea could easily come about with a fine and non-custodial sentence. But the opportunity is not there for bargaining. And you see, an accused person, through his defense counsel, should be given the opportunity to bargain and sentence. And by the way, Ian, this is done informally. I mean, when I was active at the bar, I used to take those positions. I literally say, when I look at a case, if this case is so strong against me, and I know that don't care how I fight it, I'm going to lose. Yes.
You would go and talk to
I would go and talk to the prosecutor and the judge with a view to looking at sentence. And invariably, especially in the then resident magistrate's court,
a reasonable response.
Usually, they say, if you plead guilty, we'll consider non-custodial. Because in the parish codes, usually they're minor matters, and a non-custodial sentence is appropriate. But I would like to extend and put in the legislation the possibility, at the discretion of the judge, that in minor matters you don't record the offense. Because once you record the offense, it goes against you in terms of jobs, in terms of visas, and it remains with you for a long time.
If the offense is not recorded, that would give an incentive for the person to plead guilty.
Absolutely.
Because the person would know that there would be no repercussions.
Absolutely. So
at Kingston.
this is something that I'm hoping to
It's a creative
engage
response.
the public with a
Yes.
legislation over the next few months. As I see, the legislation is there, but it is too restrictive. I want to open it up, make it broader, so that the defense counsel, the accused, can be a part of the bargaining in terms of the sentence.
Yes.
Now, in civil trials, it's clogged up with cases that have gone on for years. Now, in the Supreme Court, it's mandatory that once a civil case, that you have case management and it goes to alternative dispute resolution. About 40% of the matters are settled at alternative dispute resolution. I'd like to see a higher percentage. In other words, you know, these civil cases tie up millions of dollars, billions of dollars. And the country needs these billions of dollars to get into the system to create jobs and economic growth. So I really would like to see more of these civil cases settled, and I would like to see more of these cases being tried on a timely basis. But if we can move out some of these minor matters, use alternative dispute resolution more broadly to resolve some of these cases, then at least more time will be available to have these cases being tried. But I have a number of proposals in terms of increasing the number of judges.
Yes. Minister, there's so much to talk about. We can't do it in one program, so we're going to bring you back next week because we want to talk about those other proposals. Minister of Justice, Honorable Delroy, with some really exciting initiatives to deal with the improvement in the justice system. I mean, justice is so critically aligned to security. We can't deal with the crime problems. We can't deal with the issues of security unless we effectively deal with justice. Next week, the minister will be back to talk to us. Until that time, Ian Bourne wishing you a pleasant day.